A récemment publié une étude.
Merci beaucoup, Monsieur Premier Presidente. That was one notable statement he made, that how a country looks at liberty and prosperity should also be assessed against the cultural background of each country. Our next speaker is Señor Juez Santiago Otamendi. Es un juez de Buenos Aires. Antes del nombramiento como un juez, he was with the World Bank as a consultant, and he was a director of the Access to Justice of the NGO department of Unidos por la Justicia. The Centro de Estudios de Justicia de las Americas, whose experience is going to be shared with us by Señor Juez, is an international agency with technical and operational autonomy, which develops activities, program of action for the consideration of the country's judicial reforms process. Ladies and gentlemen, vamos a oír Señor Juez Otamendi.
Thank you very much. It's really a great pleasure and an honor to be here, sharing with you my thoughts, my ideas, learning a lot in these 2 past days. As you know, I flew almost 34 hours. I'm still safe and healthy, strong to speak with you. I want to say especially thanks to Chief Justice Artemio Panganian and all his staff, especially to Evelyn Dum Dum. We shall import her know-how. And let me tell you that really I feel as I'm in my proper home. I can experience Filipino kindness, always having a friendly smile, and they were very good for me. So now, I shall tell in my short speech the role of judicial system to contribute for safeguarding liberty and prosperity. So first of all, just a few comments about my country. As you know, I'm in the South American region. It's the eighth country, the huge eighth country in the world. We have a lot of natural resources, but in the region we still have a lot of poverty. So it's a great deal, a great challenge for us to safeguard liberty and prosperity with that frame, with that photograph, no? Excuse me for my English, it was better some years ago. I will make a lot of spelling and grammatical mistakes. But which is so that the role of judicial system. Our Chief Justice Helen Hayton and Justice Lorenzetti, both from our Supreme Court, encourage our staff, our judges, to have a cultural change, to change our role, not to be so academic, so to face the problems, to be almost moderators, to learn about reality. If we know about reality, we will be fair, we will be just, we can be more fair. So first of all, in Argentina we have, and in the region, we have the problem that most people, they just don't even know their rights, you know? We made a special measurement about this. We went with university students all over Buenos Aires and in the region, and we realized that they didn't know their fundamental rights. So our first question was, okay, if they don't know their rights, and we have all our law settled here, our constitution, our modern constitution, and we settle down all the international agreements, how are we going to afford this problem? So in Buenos Aires we decided to go out of the office, just to face the problem and to help people to educate us. Chief Justice from Canada taught us. So we encourage, in a shared effort with the Bar Association and the civil society, several projects concerning to access to justice. So one of those projects, just to tell you, is the bus to access to justice. We develop a bus and we go all over the neighborhoods and we inform people that we are going to go to one neighborhood or to another, and we just tell them the fundamental rights, and we hear them. People want us to hear them. Which are the problems? And they want to know, they want to speak judges. Because judges are in the building so far away, you know, and poor people, they have to work, they have to deal, to think what are they going to eat on the night. So if in our region we remain in our office, it's almost like a divorce, you know, people one side and judges other side. So we decided to go outside, to carry our offices in this justice bus. And it's important the citizen participation, because these efforts and these projects are impossible to be done if we don't do it with a shared effort, cooperation, to coordinate efforts. Another project that we are dealing with are the manuals of legal popular education. We just say it in not in slang, but almost slang, in proper and simple ways, in words, which are the fundamental rights, and we draw in the other side like a comic. You have this problem, these are the menus or the choices you have to face that problem. We also do that with the Bar Association and the citizen participation and some businessmen who are interested in these topics. So I address two main subjects now: the importance of access to justice and our cultural change in our role of judges. Both topics simultaneously, no? So the other important subject in our region is to develop independence of judiciary. As Artemio taught us today, the prosperity and liberty is an end in themselves, no? It's an ultimate end in themselves. So in our country we need to develop independent. And we import some institutions, as in France, the Council of Magistrates. The Council of Magistrates is an independent institution that select judges. So by that way, in a very huge procedure, we select judges and we look for the special role, for the special building of judge. So those are the main subjects to face in our country: liberty and prosperity, building an independent judiciary, addressing the importance of access to justice, and the cultural change of judges. But we still have problems, as most countries, so we have to face with all practices. We have to face also with corruption, as Chief Justice Kennedy told us today in the video conference. And we have to face also with antique codes, antique laws. And in our country, we are developing now the process of civic dialogue. We sit down together in a big table, judiciary, executive, legislative branch, the representative from the citizens, the Bar Association, and we try to exercise the future scenarios just to view how it's going to be judiciary in 5-10 years, and try to address which are going to be the problems and which might be the solutions we can give for those problems. So we are spreading out this exercise of dialogue. And to finish my speech, let's say that in our agenda for judicial reform, we promote political support for long-term policies. We disseminate, as I say, the civic dialogue in different provinces. We exchange, as we are doing now when we work together, when we have lunch, the relevant successful experiences, the implement of the new role for judges. We also are trying to implement the RAD, the REA, the alternative disputive resolution methods, and also strengthen transparency for corruption. And as well, we have our current challenges. The judicial system is collapsed, so here's the necessity, as it is collapsed, is the necessity to incorporate this alternative dispute resolution. We have all these unsatisfied legal needs, so we are trying, as I told you before, that people just address and know their fundamental rights and how to enforce system of justice to work. And we have a bad use of the new technologies. Me being a judge of Buenos Aires, if I have to make a witness to come from almost 30-40 kilometers, I have to write a note that goes to a special office, and that special office goes to see the witness, and he's telling the witness, Judge Otamendi is calling you. We don't use yet mail to do those things. And we made a measurement about how much does that cost to judiciary. And believe me, and you can imagine this, that we are going to save a lot of money if we incorporate the new technologies for these little things that is the everyday work in our offices. So my final thoughts: only through an efficient and independent judicial system can liberty be guaranteed. The judiciary is the only barrier against the abuse of power and plays a key role in reestablishing the social equilibrium. This is a constant effort because judicial reform never ends. We have always tried to look to future scenarios just to face out what are going to be the problems. It's a continuously process. And the elements for success, as I told you, is the access for justice for all, the new role for judges, and also the shared job with other agencies of government. So as one told us today, judges, we are peacemakers. So as John Lennon told us some years ago, let's give the peace a chance of peace, okay? Thank you very much.
Muchas gracias, Senor Juez Otamendi. Would like to tell you that Argentina does not have a monopoly of some of its countrymen not knowing their rights. It was on this account, among others, that the Philippine Supreme Court embarked on the Access to Justice project, including the Access to the Poor project, which involves, again, among others, the filling of justice on wheels buses, which had proved to be so far successful. Our next speaker is Chief Justice of Nepal, Dilip Kumar Patel. Nepal is a country mountain at the lap of the Himalayas between China and India. Chief Justice Patel rose from the ranks, and he was appointed as Chief Justice in July 2005. With his background and his Bachelor of Arts degree and other educational attainments, I am sure he will enlighten us on how Nepal has so far understood or experienced the judicial philosophy of liberty and prosperity.
Thank you, Chairperson. Honorable Chairperson, Honorable Chief Justices and jurists, distinguished delegates, ladies and gentlemen. At the outset, I would like to extend my sincere thanks to Honorable Artimo B. Panganiban, the Chief Justice of the Philippines, for inviting me to participate in this global forum on liberty and prosperity, organized by the Supreme Court of the Philippines. Let me also on the record my deep appreciation for the warm hospitality extended to me and members of my delegation. Coming from the country of Mount Everest and birthplace of Lord Buddha, I have brought greetings and best wishes of the Nepalese judicial community with me for the success of global forum, with progress and prosperity of the people of the Philippines. I think the theme of this forum is highly philosophical and mind-boggling. Yesterday, Honorable Chief Justice of the Supreme Court rightly remarked this word, I think so. That's why I repeatedly this word has quoted. Both the liberty and prosperity are interconnected and inseparable with each other. We cannot imagine liberty without prosperity and vice versa. It encompasses both libertarian and egalitarian values in a given situation. That theme has been chosen for the global forum and the modality that has been adopted for sharing experience of the different sectors such as judiciary, the bar, the executive and academic is a very significant. The perspective that each of sectors present in the forum will not only help us to enrich knowledge on the struggle made in each country in safeguarding the liberty of the people and nurturing prosperity of the respective societies. As we know, there are threats to equality, liberty, and pursuit of happiness in every society and every state. However, factors inhibiting their full realization in each society and country are different. We have many challenges in establishing democracy, the rule of law, which are bedrocks for prosperity and happiness. It is from this point of view I venture to share at this august forum the experience of the Nepalese judiciary in safeguarding liberty and ensuring prosperity of our people. While doing so, I would like to focus on the experience of the judiciary in the last 16 years following the unveiling of the current constitution in 1990. Sandwiched between two great countries of Asia, China and India, Nepal is a small mountain country in the lap of Himalaya, which has always remained independent. Our system of law and justice grew with our experience of the succeeding centuries, though the walk towards democracy remained disturbed and affected by different political upheavals up to 1990. The judiciary tried its best to protect the liberty and the fundamental freedoms of the Nepalese people, even in difficult times. Through the 1919 Constitution, Nepal has made commitment to the rule of law, fundamental freedoms, and human rights as the milestone of the democracy. The Constitution, for the first time, recognized the people as the source of sovereign authority. Independent judiciary is one of the three pillars of the state under this arrangement. The Constitution aspired to establish a system of justice which is independent, informed, and competent to protect liberty, fundamental freedoms, and human rights of the people. The Constitution vested the Supreme Court with the power of judicial review. It is interesting to note that any Nepali citizen can file public interest litigation to the Supreme Court for the protection and promotion of the public interest. Probably, Nepal is the only country that incorporates public interest litigation in its constitutional text. In most of the countries where PIL has been recognized, it is the judicial interpretation that established PIL in their respective systems. The Constitution has created sufficient space for the judiciary to shoulder its role as custodian of the Constitution, make significant efforts in protecting equality, liberty, and rights of the people, promoting good governance, institutionalization, democracy, and the rule of law in Nepal. Since the courts and other institutions in Nepal now imparts justice in accordance with the provision of the Constitution, the laws, and recognize the principle of justice. Where necessary, they can now internalize values developed in international and comparative jurisdictions. Any dispute which involves the question of interpretation of the Constitution or the laws, or which can be decided through the judicial manageable standard law, falls within the jurisdiction of the Supreme Court. The wide jurisdiction of the courts makes it possible to have a judicial scrutiny of the executive action, control the abuse of power that impinges on the liberty of the people. The 1919 Constitution aspired to make human rights and the rule of law a living reality. Nepal, by acceding to most of the human rights instruments and through the provision of Nepal Treaty Act, has been opening up the scope for internalizing international human rights instruments and their domestic enforcement. As a result, protection of human rights became a concern of all the state instrumentalities, including the judiciary. While the Constitution of 1990 established a very bold framework of the rights and independent judiciary for the enforcement of these rights, the succeeding years saw many challenges pertaining to the processing of the democratic aspiration of the people, strengthening democracy and good governance, promoting quick revival of the economy. As the result is placed in a unique position to address many of these challenges, having constitutional and legal ramifications. Many disputes were brought to the court during the last 16 years since the promulgation of the Constitution. I will not able to present before this august gathering the experiences of the judiciary in all these areas. I will pick up a couple of cases that pertain to liberty or in some ways are very valuable significance to this floor. First group of the cases relate to the interpretation of the Constitution and striking out inconsistent provision of the laws through the exercise of the power of judicial review. Many cases such as ones relating to the protection of civilians from being picked up by military courts, facilities in the jail, and disputes relating to equality and discrimination were decided by the Supreme Court. Many of these cases, Supreme Court declared disputed provision of the laws ultra vires. In the second group of cases, the Supreme Court had to grapple with issues where there were no laws to make it possible for the people to realize rights. Rights of women over parental property, rights against sexual harassment, conjugal rights during the marriage, including the rights against marital rape, were some of the issues brought into the court by the enforcement of right to equality and liberty. In these and many other cases, the court has issued directives to the government to enact necessary laws or streamline existing laws to twin them with the guaranteed right, making the realization of the rights of people. Third group of cases relate to the enforcement of existing rights, including personal and civil liberty. On cases relating to personal liberty, the Supreme Court has right from 1950s have emphasized that the exercise of police power should be guided by the principle of the fair trial, thus taking people in detention without valid reason, denying basic human rights during the detention, not respecting the right to fair trial, have been frequently questioned by the court, and many path-breaking judgments have been handed down. This judicial wisdom has been further strengthened following promulgation of the 1990 Constitution. In many cases, the Supreme Court has quashed the decision of the government and other public authorities affecting the personal liberty by putting persons in preventive detention, encroaching upon the right to privacy, and denying access to information held by public authorities. Most critical part of the course of the Supreme Court during these 6 years is the settlement of disputes of the politico-legal nature. These cases may or may not be directly related to the liberty, but are concerned with governance and prosperity of the people, country. Disputes have come in varied forms to Supreme Court, such as dissolution of Parliament, declaration of state of emergency, or the misuse of government funds by the parliamentarian. Principally, the Supreme Court made it clear that it will stay away from deliberating and deciding political questions which did not fall within the parameter of the judicial standard, or where policy questions or governance were involved, and disputes which could be more effectively resolved by the executive or the legislative than by the courts. But when a matter involves a constitutional legal question of national importance, it does not draw back from the entertaining such dispute simply for the reason that the matter involves a political question or a question with political ramification. While one of the early cases of the politico-legal nature was the dissolution of Parliament, where the Supreme Court takes the distinction of being among very few judiciaries in the world, reinstating the House of Representatives, the lower house of the Parliament. More recently, the Supreme Court successfully tackled with disputes pertaining to the use of state power during emergency. As happens almost invariably, many fundamental rights were curtailed during the emergency period, which made it difficult for the people to approach to the Supreme Court, praying for the protection of personal liberty. At this difficult moment, the Supreme Court of Nepal stood by the side of people to protect their rights against arbitrary detention. Besides, it also opened its door to the people for the enforcement of non-suspended fundamental rights during the emergency for interpreting Article 82 of the Constitution. Another interesting case is regarding the test of constitutionality of the Royal Commission to investigate corruption cases by invoking emergency power. The commission was continued even the emergency was lifted. The commission had the power of both prosecutor and court. It could investigate, try, and dispose of the case. This exercise of power by the king had a serious impact on personal liberty of the people. It was also a testing time for the judiciary, and I am happy to say that this time also the court rose to the occasion and quashed the order of king to establish the Royal Commission. Further, rejecting the claim of the government that king had used the state authority vested in him, the court observed that since the present constitution had clearly laid down where the sovereign power and state authority lies and how it should be exercised, there is no reason to have any confusion about these powers. Thus, court was refuting the claim the king was using the state power with regard to the use of Article 127, the court observed